also in many respects more sensitive than many other international or cross-border type of transactions. And it is not a coincidence that technology transfer deals are regulated or the subject of regulation in many, many countries. You know, even an advanced country like the United States still requires patent applicants to get a government license in order to file a patent application abroad. Not very common in other countries, but still the philosophy of the government or the regulating agencies want to know what kind of technologies are homegrown but then sent overseas, because technologies can be very sensitive, and they can be sensitive in many areas. Of course, defense is always a very sensitive area, but not only defense. Medical, healthcare technologies can be technologies relating to food, drugs, any other type of human care type of technologies are always very sensitive and are always subject to regulation. Now, all of these are thorny issues. They require special attention when you are either in a transferor, position of the transferor, or the position of the transferee, the seller or the buyer, the licensor or the licensee. All are subject to various rules and regulations which change from country to country and make this transaction different than your normal sale or license transaction. That is not only because intellectual property is different in many respects. It's intangible, it is universal in its coverage, it is applicable in many ways, and it is much more difficult to protect than other assets, other properties. The result is those thorny challenges that come up, and I would like to point to 3 or 4 of those which are unique to the technology transfer transaction and are normally not found in other commercial transactions. In most international transactions, it is always on the checklist to have a governing law clause and a authorized forum clause. But these are usually not taken very seriously, and they are very often at the bottom of the checklist of things to be resolved in negotiations for an international transaction. That kind of attitude would be a grave mistake when we look at an international transaction for the sale or license of technology, especially in the more common format of a license. Why is that? Because when you license a technology from an owner in one country to a recipient in another country, you are in a long-term transaction. And the long-term transaction means that there are different obligations that are binding both parties, but the one who's in a more sensitive, fragile position is the seller, the licensor, because the licensee can take all the technology and then stop paying royalties or ignore territorial limitations or ignore field of use restrictions. And then what remedies are available to the licensor very much depend on not so much on governing law, but who is the forum that will resolve the differences. So if you take a typical transaction between a licensor in country A and a licensee in country B, and then the licensee violates the agreement and the licensor wants to enforce it. Now, many licensors, especially larger corporations, as a rule prefer to have the governing law and governing forum in their home country. So if it's a large US company which licenses technology to an Indian company, you will almost always find that in these license agreements, the authorized forum would be a US court. And that could be a grave mistake. Why would that be a grave mistake? Because in a situation where the licensee violates the agreement, the licensor, typical in an IP conflict, would seek intermediate remedies, would seek an temporary injunction. Now, under the various private international law rules, and especially the Hague Convention for the Enforcement of Foreign Judgments, intermediate holdings are not enforceable internationally. So if our large US licensor company has licensed that technology to an Indian licensee, and the Indian licensee stopped paying royalties, the licensor can go to a US court and file for a claim, but also for an preliminary injunction, and the US court will issue that preliminary injunction, but that would not be enforceable in India. And if you did not make the proper arrangements to be able to enforce intermediate injunctions, intermediate remedies in licensee territory, you have nothing. You'll have to wait 2 or 3 years until you have a final judgment, which also means a judgment after final appeal, in order to be able to enforce it in the licensee territory. That's very ineffective. Solution? Different solutions. One can pick a court of jurisdiction in the licensee country, or something that we've seen happening more and more in recent years is agreeing in a technology transfer deal that the licensor or the licensee, whoever files a claim, can determine which court will have jurisdiction, which will be either the licensor court, or country court, or the licensee country court. Very important in order to be able to solve a conflict in the initial, usually very critical stages of a disagreement. Another issue that has become more in focus in recent years is the issue of anti-competitive restrictions in license or technology transfer agreements. Many technology owners, technology sellers or buyers, licensors or licensees, are often either indifferent or simply not aware of the fact that many jurisdictions around the world do not permit a whole host of restrictions, anti-competitive restrictions, or at least so they are viewed, which have been and still are common in some technology transfer agreements. Let me give you a few examples. It used to be very common in technology transfer agreement, especially patent licenses, to agree that the licensee will never contest the validity of the patent. There are all sorts of beautiful moral and philosophical excuses for such a restriction. It is now almost universally not permitted to enter such a no contest clause in patent or other type of IP transfer agreements. There are good reasons for that, because the public in general has an interest that patents which are invalid should not remain on the register. There is a public interest in removing invalid patents. So it is not wise to allow two sides to a patent agreement to restrict the right of anyone to challenge the validity of a patent. And who is the most natural candidate to challenge the validity of the patent than the licensee, who has to pay royalties for exercising patented technology where the patent, at least they think, is invalid. There are other types of such restrictions which are commonly outlawed in many countries these days. For example, pricing restrictions, especially when the license or the transfer agreements is between two competitors or potential competitors on the same horizontal level. And another type of provision that used to be very common in the past is post-expiration obligations on the recipient of the technology. It used to be common to agree that licensee will have to pay royalties even after the patent expires. That has become almost universally outlawed in most jurisdictions. So when we do a technology transfer transactions, we should be very well aware of the different laws that may apply to this transaction. All of us are very familiar with the laws in our own countries, with the legal environment that influences this type of transaction in the jurisdiction with which we are most familiar. But we need to be equally aware of the law and especially the restrictions on such transactions in the country of our counterpart. And finally, the world has changed in the recent generation in terms of the tendency to allow more and more free trade. Free traders, or the proponents of free trade, have a problem with the very territorial attitude and basic concepts of IP. We always say that despite the fact that the subject matter of intellectual property is universal in nature, IP laws are very territorial, and IP rights are very territorial. It is very strange that we take a flight from Delhi to London, we take a bag with us, and when we descend from the plane in London, the bag belongs to us. But if we have patented technology in India and we fly to London, we get off the plane, that technology may not belong to us because we haven't registered a patent or someone else beat us to a patent in that other country. Because one of the basic tenets of IP law is that it is very territorial. Proponents of free trade who have had the upper hand in at least the last generation or two regard IP laws as what they call a non-tariff barrier to free trade. And there's always a competition, not to say conflict, between proponents of IP and proponents of free trade. One area where that has affected more than others is exhaustion of rights. We're familiar with exhaustion of rights. In some areas there is exhaustion which is universal, primarily on trademarks and to a large extent on copyright goods. Patents remain very territorial, and as a rule there is no exhaustion of patent rights between different countries, although there is exhaustion within free trade organizations or multinational single market organizations, as is the EU, for example, and other organizations. That also affects technology transfer deals in many respects. For example, in a typical technology transfer deal, it would be normal and would be legal to divide the markets and say license patented technology to a licensee in another country, but restrict them from exporting their products to other countries, to other jurisdictions. That could be and is a very common characteristic of international licensing arrangements. But then the goods themselves may be subject to exhaustion, and therefore you can try to license someone in another country and restrict them from exporting to other countries, but the goods are free to travel to other countries because the rights that protect them have been exhausted. So there again is something that we have to follow up with very closely to see whether we're doing a deal which is actually written on ice and will melt immediately because the legal environment does not permit the exercise of these different restrictions. There are many more, and I'm sure we'll get to them with some of Vanessa's questions and other comments here. Thank you.